meeting. I'll tell you later.
Well, it is 9 a.m., so seeing that everyone's here, if everyone's ready to go, I will call the meeting to order. Are there any additions to the agenda? Okay, hearing none, we'll move on to approval of the January 13th special meeting and the January 14th special meeting minutes. Do I have a motion to approve those minutes?
So move.
Second.
I have a motion and a second. Any further discussion about the minutes? Okay, we'll take a voice vote. All in favor, say aye.
Aye.
Aye. Opposed, same sign. The minutes are approved. Okay, Rebecca, number 4, you are on.
Great. Well, happy January, everybody. I'm going to turn it over to Alicia, as always, with our budget update to start.
Okay, good morning, everyone. For December's budget update, I'll just notate right away, we did have quite a bit of changes, so I'll go over the majority of what the big ones were here, but just to give you a heads up. So the current appropriation for the 23-25 biennium is now at $1,167,769. You'll notice in here there's a line item added right here for $12,472. This is that 75% that we received for that grant we applied for the Student Internship Program Spending Authority grant for Patrick here. So that has been transferred into our spending authority, which has increased our appropriation. Our expenditures in December totaled $57,844, bringing our total expenditures for the biennium to $805,750, and leaving us a remaining budget of $362,018. Our projected expenditures are at $346,763, leaving us with a projected ending balance of $15,255. That will obviously fluctuate as changes move through the rest of the fiscal year here. So some of the major things to point out outside of the appropriation that we had allocated for Patrick were an adjustment to our projected travel. We did get rid of some of the travel dollars we projected just due to only having one person attend Kogel and not two. So that saved a little bit there. We did also add $1,500 to our data processing projection because of the meeting notice form that you guys had approved last meeting, or excuse me, in, I believe, December's meeting. We had some IT equipment for the intern that we initially thought, as it was going to be loanable, was not going to have to be paid for, but we did actually have to purchase monitor and keyboard and some things for that position. So that also came out of here. We also added just a small LinkedIn learning training thing for staff, which was around $115. So pretty minor change, but on there as well. So any questions at all for December's budget update?
Any questions from the group? Okay, thank you, Alicia. Next up, Rebecca.
Yep, we will move on to our filings update, which I also will ask Alicia to pull up. For the month of December, this is what we received. So you will notice we received 3 complaints in December, no quasi-judicial forms. You'll note that there's nothing in the graph there. We had 4 general conflict of interest disclosure forms that came in. And then the most significant filing that came in during the month of December was those meeting notices. So just as a reminder why that number is high, or why we have as many as we do, Those are the required filings or forms that need to be completed by sponsors of either private or public social and educational events that are happening with the legislature starting on January 7th or at the January 6th, January 7th, around there. These meeting notices do tend to increase the closer we get to legislative session. Just an overview, we now have 2024 numbers for the entire year for all of these different filings. We did not create a chart for this because we usually just create a chart for the month, but I would like to let the commission know total complaints that we received for the month, for the year 2024 came in at 41 complaints. Quasi-judicial forms, those are the ones that talk about that appearance of bias. Those came in at 30 forms, and we received 16 conflict of interest forms. As far as meeting notices, the commission received a total of 151 meeting notices during 2024. Those numbers all have increased since 2023, which is kind of expected with the meeting notices, the conflict of interest, and the quasi-judicial. As people learn about those particular rules, those filings will come in. The commission currently has 30 pending complaints. Any questions from the commission on those numbers? We did provide this information. I'm sorry, I asked a question and then I wanted to provide more information. We did provide these numbers as well as numbers for previous years to the budget during our budget hearing. And so we'll get to those attachments and what we provided later on, and you will be able to see the numbers year over year. Any questions, comments, concerns about these filings, data? Hearing none, I will move on to our advisory requests update. So you will notice that on the executive director's report, what is missing this month is education and outreach. Once we wrapped up our educational training sessions to go into session, we have now transitioned almost entirely to handling proposed legislation, working on our budget, or doing complaint work during legislative session. We don't have the bandwidth to be doing education at the same time. Obviously, we can answer questions that people have about processes, directing them to our FAQs or directing them to rules that we need, that they need to look at. But generally, we will not be doing a whole lot of education during legislative session, just with our resources allocated the way they are. We do have a few coming up, but we'll let you guys know about those in February. So just a update on advisory opinions then. So we have recently received 3 requests for advisory opinions. Commission staff, in coordination and in consultation with Chair Anderson, have communicated with two of the requesters that the commission will issue an advisory opinion. You will see in your packet of materials the most recent request for an advisory opinion. This is a very thorough request. There was a lot of information included in that. We did consult, by meaning we, myself, with our general counsel, Logan Carpenter. We communicated and consulted with Dave, but because of the nature of this one, we decided that we may want to discuss it at the meeting, and just kind of let the commission be aware of it. So I'm going to turn it over to Logan to kind of talk about that. Dave, how much in depth do you want to go on this one? Maybe we'll look to you for direction on that.
I think just a summary, because I would call it, it's involved campaign finance, and it's rather detailed. And my concern for the commissioners is, I mean, there are a couple ways we could go with this, but I'd like to, Logan, when you bring the discussion around, is it's a complicated subject, and I am not sure the commission. Logan will talk about that, but it does fall within our purview. but it's a wide open thing, and we're talking campaign finance, and we'll have to think about that one, how we want to approach it. So Logan, take it away.
Sure. So, as you can see on the attachment, the request relates to whether candidates for office and public officials can use campaign funds to pay for dependent care expenses and security expenses related to campaign activity and their duties as a public official. So the requester did a really nice job of providing resources for us to look at to analyze this request. Currently, under federal guidance from the Federal Election Commission, they've opined on this issue when it relates to federal campaigns and federal candidates quite a bit. So essentially, federal advisory opinions on how to handle this when it comes out when you're a federal candidate. But the question comes under North Dakota law. There's a lack of clarity whether this is a permissible use of campaign funds for state level candidates and people under North Dakota law. So it's clear that there's a question of whether that's permissible. When it comes to the commission, we look to what's within the commission's purview. It has authority over state laws related to transparency, corruption, elections, and lobbying. Arguably, this request falls in 3 of those buckets with corruption, elections, and transparency. Flip those around. You get the gist of it. So when we look at the advisory opinion statute, it directs the commission in response to a request to analyze state statutes and ethics commission's rules related to transparency, corruption, elections, and lobbying. Well, this is a state statute addressing 3 of those issues, even though the commission does not necessarily have rules related to elections to date. Now, the question comes, in my mind, I guess in our discussion, that the commission could analyze this issue in one of 2 ways, because the statute at issue puts a Class A misdemeanor criminal penalty on the use of the impermissible use of campaign funds. So the commission could either analyze it in the advisory opinion, or we could potentially get a complaint if somebody proceeds and acts and uses their campaign contributions to do one of these things, and we would have to then analyze the statute to determine whether we are mandated to refer it under our referral statute that requires us to refer things that associate with a criminal penalty. So we thought it was prudent in our discussion to analyze it on the front end and go through the advisory opinion process and do that analysis of what is allowed, so we can give that guidance, give that education on the front end through an advisory opinion, so the commission does not have to analyze it on the back end if we get a complaint.
So Logan, explain what that means to us. Like you're talking about, we're not going to get into details and create campaign finance law. We're trying to give guidance on what the law currently provides.
Correct. Yes, we would do the legal analysis to see what the law directs candidates and public officials to do, whether that is a permissible use or not of their campaign funds. And the answer may be, well, it's not clear, so we need to have somebody else address this issue. There's really no way to do that analysis without actually going through the process of the advisory opinion and seeing what the outcome is, what the research and what the law provides.
But I think can I just jump in? Sorry, the scope of the advisory opinion needs to be in the context of that the commission may be asked to do this or evaluate this issue in the future.
Yeah,
And so it is limited in that, within that scope.
yes, there's two ways the commission could be asked to address this issue, and I think the commission has directed, yes, we'd rather do it in the form of advisory opinions than in complaints. So there's an advisory opinion request here. So the idea was, yeah, let's address the issue. So if we do get a complaint, the commission has essentially given itself that clarity of whether or not that it has to refer something based on the context of the advisory opinion.
So
Dave,
yeah,
this
go
is
ahead,
Murray.
Murray.
Just for clarification, if the commission accepts the complaint, it triggers a 60-day response time. Is that right?
So if the commission says that it will issue an opinion, the commission has 90 days to issue
Okay.
the opinion.
Okay.
Right. So
So-
it's 90 days from the 14, and we get 14 days to respond to let the individual know whether we will issue an opinion or not.
So Dave, I agree with you that this is a very complex issue, and it's just as complex for people who are campaigning. And it is just a suggestion that the commission decide to take this matter, but the timing is truly inopportune because we're in the middle of the session and campaigning doesn't start until after the session. So I'm just throwing this out, is that tentatively the commission agreed to accept this opinion, but ask the the person submitting the request, to either grant an extension until after the session or withdraw it and resubmit it after the session, because this deserves a thoughtful consideration and the timing is just not good right now. My thoughts.
Yeah, and the problem with this request is, as I see it, there's two ways we can go about it. It's advise, because the trouble is the request references federal law, which is a little more clear. The state law is not as clear and generally has categories. And it seems to me that when we develop an opinion, our advisory opinion may include that the state law is unclear.
Which requires some guidance.
Yes, yes,
Because it looks like it's a minefield. And,
yes.
and so to give an advisory opinion, I think is far better than wait until somebody steps on a mine, and which creates a potential criminal penalty. And I think this would be a valuable service to any candidate. So just my thoughts. I'm done.
So you're still advocating, I agree that this time is not opportune to render an opinion that's this complicated.
I believe that my recommendation is that the commission issue an opinion, but not until sometime after the legislative session, so that the commission can focus on the legislative session and pending complaints, and then give deliberate consideration to it after the legislative session.
Yeah, I think that's reasonable. Rebecca, Logan, what do you think?
Yeah, I think that that's very workable, and I can take that request to the requester and see if they would either agree to an extension, if they want to do it that way, or if they would like to do it in withdraw it and then refile it. So I can take that approach. We can say that we'll issue it, but obviously we need more time given the legislative session. But I think that I can take that to the requester and then report that information back to Dave. And then we can consult based upon the policy that the commission has adopted and go from there and make a decision from there.
So Rebecca, would we be essentially then tabling the issue or the topic? Or no, is that not the right way to couch this?
Yeah, so Cindy, the way that we have this in the policy and procedures for the commission, I want to go to them quickly. It is that whether the commission issues an opinion or not is determined by thank you, Logan. I'm going to read this word for word, Cindy, just to make it very clear. It says, upon receipt of a request for an advisory opinion, the executive director will consult with the chair and determine whether the commission will issue an advisory opinion, and then subsequently, or at the same time, determine whether the names of the person in the opinion and request are an open or closed record in accordance with the 546604.2. So we don't need a motion from the commission. We certainly can have one to do that, although I don't know if we need one.
No, I don't think we need one. What we can do is work with the requester and Rebecca and Dave, and then go from there to decide, given the direction the commission has discussed today, whether to issue it on this request or to wait and see if the requester wants to resubmit it later, and then go from the new request, the 90 days from that date, and then issue it then. So I think it's within the purview of Dave, Rebecca, and the requester to figure out a timeline that works.
I like that
Okay.
approach.
Yeah. Thank you for clarifying.
It's fine with me.
Okay, sounds like we're in agreement, so I think that's how we should proceed.
Okay, we will go ahead and do that. That concludes our advisory request update. We do have two other pending advisory requests that commission staff are working on, and we will have those in upcoming meetings ready for the commission's review. The next portion, or the next item on the executive director's report, is a COGL report, and this is really just to put on the agenda because we are providing the written comments from Murray. He was not inclined to provide any further discussion at the meeting unless any of the commissioners have questions for Murray, but he did submit a written report. I think most of it was summarized in what he shared with the commission about COGL during the December meeting. So any questions for Murray on the report that the commission has as attachment 6?
Don't have a question, but I appreciate his report. It sure sounds like he felt it was worthwhile.
Yeah, I agree. Thank you, Murray. But it's like, oh, darn, I think he's set another standard for us. Mike, because I did not do a written report. I know I did a verbal one, but I appreciate it. I also appreciated the questions at the end, because they were like right on, and it's like, oh, we've kind of touched on these things already in previous discussions over the years and that, but to bring them back to light. So good job. But probably a new standard that, yeah, okay, for traveling, we should probably put something in writing.
So Cindy, we did put some, I'm just going to pipe in because you didn't give yourself enough credit. You did put something in writing. You just had Logan and I do it. So you told us what to put in writing. So you did do it.
Thank you.
Anything else on Kogel?
Well, I do have one follow-up comment, and I put those questions in there not only for my thinking, but also for others who read that report, is that what we see, the Ethics Commission provides a service to the state at the state level. And how can there be a similar ethics type programs for cities and counties? And most of our cities and counties are way too small to develop a staff to do something like this for complaints that may come in only infrequently. So just something to think about, how there can be some kind of a ethics program for local governments. Just a thought.
Murray, as the executive director and attempting to do our best to effectuate the language of the Constitution, I think all three of these questions are things that I and Logan and Alicia have asked ourselves. We are attempting your question too about case management system that we are addressing with the legislature, and that is something that we need to do. And then also that balance of confidentiality and transparency. So I think that these were excellent questions that really are a thinking and things that we should think about as we look to what our strategic plan will be in the coming biennium. So thank you for those. I appreciate that.
Yes, Murray, thank you. That was very helpful.
What I especially liked about Murray's report was the phrase, the collective wisdom of the commissioners.
Second, that. So am I good to move on to our legislative updates so you guys can learn about what we have been doing and working with the legislature?
Yes, you can go ahead.
Okay. So legislative update, we have been busy. We will continue to be busy on bills that are coming up over the next few weeks before crossover. And we're not halfway through, but we are continuing to work diligently on all of the bills that affect the duties, authority, and operations of the Ethics Commission. So I'm going to start with Senate Bill 2004. This is the Ethics Commission's budget. Just as a general overview, when we talk about budget, Alicia has really taken up the torch and has the numbers calculated down to the penny. The committee that we were in front of this last week really appreciated the detail that we were able to present to them. And I really want to thank Alicia for the work that she's done on that. So in the memo that you have before you, you will see that there is, I outline again, just as a matter of review, the commission's base budget, and then the optional packages that we have included. Now, what is unique, not new, but certainly not consistent with this legislative session as opposed to last legislative session, is that we had essentially two executive recommendations. So there was the one first presented in December, which is the Burgum recommendation, and then we have the new one that came out last week, which is the Armstrong recommendation. So we have two executive recommendations. They did not change, neither of those executive recommendations changed the packages that they included for the commission. The only change was overall the cost of living adjustments and the raise adjustments for state employees. and that will affect the Ethics Commission's budget, but there was no specific changes from the Burgum budget to the Armstrong budget with the packages that were included. So just a reminder, both of those executive recommendations included decision packages 1, 3, and 6 through 9. So 1 is the increase that we're seeking for commissioner and temporary salaries. 3 is our IT software and subscriptions. And then 6 through 9 consists of that case management system, which we just briefly talked about. And then our professional and legal services. This we are looking, this additional funds, these would be earmarked for just those professional and legal services. We have a little bit of furniture costs that we need to include that was included in the recommendation. And then those increased travel expenses or costs as well. There is a little slight difference between, I think it's about $7,000 or $8,000, right? Between the Armstrong budget and the Burgum budget recommendation, but that's really just due to the salary increases. Nothing else has changed. So the initial hearing that we had on Senate Bill 2004, that was held on January 14th before Senate Appropriations, the Human Resource Division Committee. Chair Anderson and Commissioner Sagsveen attended online. And I know that there was some technical issues that we ran into there with the clerks in the office, or the clerks in the hearing or in the committee, excuse me. They were still trying to get used to that. And then Vice Chair Kozer drove to Bismarck and was present in the room as we presented that testimony. We really appreciate him taking the time to come and drive to be here. So I presented testimony, and then Alicia supplemented some of that testimony. And really how we focused and why we included the testimony that we did in the attachment, the presentation, is we really wanted to the committee to understand what the commission has done in the past year, or excuse me, in the past biennium. What has the commission accomplished in the 5 strategic initiative areas that we have outlined? And so that is, honestly, that was most of the conversation that we had. That happened on January 14th. That was an overview. We will continue to do committee work with the Human Resources Division and present and answer questions. They already have 2 questions for us that they wanted additional information on. One regarding the case management system, and the other was on professional fees. They had asked some questions about those. So we wanted to provide additional information, and we will continue to do that. Alicia, again, as I said, is taking the point on this, and she knows all of the numbers, which is a huge asset to the commission as we have these discussions. Any questions, comments, concerns, direction from the commission on Senate Bill 2004?
Just a comment I'd like to make. It was interesting to be there. And both of the ladies, Rebecca and Alicia, did a great job. I was especially intrigued by Alicia. They asked her some questions, and she had the answers off the top of her head to the dollar. I mean, she didn't round up to 70,000. She would say $6,945, and it was impressive. But they did a great job.
Yeah,
I
thank you
second
guys
that.
for that, and thank you, Ward, for making the trip.
My pleasure.
Well,
Well, and I read the testimony that you provided us in our materials, Rebecca and staff, and it's really a great, I mean, I know it's testimony, but I found it really enlightening. I'm like, oh my gosh, look at all this. Because it's like I knew the pieces and parts, but it's so good to have it all together in a very succinct and clearly described narrative about our work and what we've done. So thank you for that.
and as far as Ward is concerned, he told me once he loves to come to Bismarck because he gets to drive by the New Salem cow.
Except I go through Minot.
Oh, you go through Minot, okay.
Yeah, yeah.
Well, we'll continue working with the Human Resource Division of the Senate Appropriations and give you updates as needed. And if there's any additional information we need from the commission, we will certainly ask and get that. You'll hear more likely from Alicia than from me. So, am I good to move on to House Bill 1046?
Yes, you are.
All right, so this was pre-filed by the Ethics Commission. This bill is the Commission's advisory opinion bill, and it would have or would allow the Commission to initiate an advisory opinion upon a majority vote of the entire Commission. And then it also put internal practices and procedures regarding the advisory opinions into statute. So the legislative hearing on this bill, on House Bill 1046, was held on January 8th. That hearing was before the House Judiciary Committee. I testified on behalf of the Commission at that hearing. During the hearing, some of the very first questions that I got, I should add that Commissioner Sagsbeen was online for that hearing, and then Mr. Carpenter and Mr. Friess and Alicia were also present as well if there was any questions that came up. But during the hearing, legislators really seemed to focus on the fact that the bill was introduced by the Ethics Commission. There were some initial questions about how this bill came to the committee. Why was it introduced by the committee? There seemed to be a little bit of confusion on the process or the procedure for how the commission can bring bills. There does seem to be there was a tone or a tenor that having agencies or state entities introducing bills, that they wanted it to be brought through a legislator. Specifically, I was asked why the commission felt like we didn't need to bring it through a legislator. And I don't remember the exact words of my response, but something to the effect of that this bill is very straightforward. It directly impacts the commission's work, so that is why the commission brought it forward. There was support for the substance of this bill, allowing the commission to have these advisory opinions on their own initiative with a majority or 4 out of 5. There was an amendment to add it to 4 out of the 5 commissioners. But in the end, it came out of the House Judiciary on a do not pass recommendation. And now I had to leave for the end of the discussion because Alicia and I had to go down to a different hearing. But General Counsel Carpenter really pointed out that it really seemed to be the fact that it was brought by the commission that seemed to be the sticking point. So it did come out. I do see that I have a typo. It was not a 31-1, it was a 13-1 vote. So I apologize for my typo in the memo. But the bill ended up failing on the House floor. We have reached out to somebody in the Senate to see if this could be reintroduced by the Senate. That really hasn't gained a lot of traction, but we'll continue to work on that. Senate bills need to be introduced by Friday. Any comments, concerns, questions on House Bill 1046 at this time? Hearing none. Dave, am I good to move on to the next bill? I think he said yes. Okay. Moving on to Senate Bill 2052. This was the other Ethics Commission pre-filed bill. This is the bill that we did not change the law, but was merely clarifying a caption in 546613 to add the word elected. Again, just to reiterate, this was not a change in the law that the commission was seeking. This bill was introduced after consultation with Legislative Counsel to create a record regarding the change. So this bill really it clarifies that the restriction on lobbying while in office and for 2 years after leaving office applies only to elected officials. That restriction is outlined in Article 14 of the Constitution. And so in order to understand and interpret 546613, you do need to go to the Constitution. And since there is not a similarity in language, it created some concern. The Senate Judiciary Committee did hold a hearing on this one on January 8th, 2025. So this is the hearing that Alicia and I had to leave to get to at the end of the hearing on 1046. The committee had one piece of opposition testimony. I did not include that in your materials. You can certainly go and read that online. But that piece of testimony was regarding an opinion from the 8th Circuit Court of Appeals related to Missouri's lobbying moratorium. Missouri has a constitutional provision, did I say that correctly? That prohibits lobbying for legislators and legislative staff. And that bill was challenged on a as-applied constitutional challenge. And the 8th Circuit issued an opinion this past summer. So the opposition testimony had sought repeal of this particular statute in light of the 8th Circuit case. However, as articulated in the testimony that we submitted, that Missouri lobbying moratorium is different than North Dakota's in multiple ways. The challenge that was brought was limited to the individuals who brought the challenge. It did not have a broad application. And so I cautioned the committee against making any changes to the law in that regard. The committee did unanimously approve a due pass recommendation. The bill was passed on the Senate floor. I believe it was later last week. I forgot to include a date on that. And that was on a 47-0 pass on the Senate floor. I will note that there was a question that was brought up on the floor about the civil penalty that was associated with this particular lobbying moratorium. There does seem to be some confusion, and the reason I bring it up is because it's something that we talk about in our education, that the commission can somehow find somebody criminally liable. That isn't there, don't we need to have a jury to find a criminal liability? And so we actually did follow up with that individual and discussed that issue and clarified that the commission does not determine criminal liability, it is ethical liability, and that the assessment of the civil penalty associated with this moratorium is distinct and different than the criminal penalty that is associated, because there is both a criminal and a civil penalty. So I think what we learned in that one is that there's an opportunity to educate in that area when it came to Senate Bill 2052. Any questions? So this will now go over to the House after crossover, so sometime in March. Any questions on Senate Bill 2052? Hearing none, I will move on to the other bill that I wanted to give a legislative update on, and that is House Bill 1360. This is the commission's, kind of the culmination of the commission's work on the complaint process and improving, streamlining, making this more effective, making it proactive instead of reactive. Thank you, Logan. Anyway, the bill is the commission's transition from the complaint process to more of an enforcement action. As previously discussed with the commission staff has been working with legislators on this bill, particularly with legislative leadership, but also with additional legislators. We sought feedback. We got great feedback from them. We also reached out to elected officials on this one and got feedback as well. Maybe not on this one. That was the other one. Sorry. Nope. I misrepresented. We did not reach out to elected officials on this one. The bill was introduced by Representative Christie, and it was co-sponsored by a number of individuals, including Representatives Issa, LaFleur, Louser, O'Brien, and Pyle, as well as Senators Boucher, Hogue, Roars, and Thomas. So the hearing on this bill has not yet been set. And as we're not requiring any action on this. The commission previously voted to support this bill and testify in support of this bill, but this is the final bill format and the number, the language that we had. Most of that language, there was some minor grammar changes, I believe, from the commission's bill or the commission's proposed piece of legislation to what came out of Legislative Council. So we will work on this bill. We will support this bill and testify in support of this bill when the hearing does happen. We will let the commission know when this bill is taking place. This is one of those bills that it would be really fantastic to have some commissioners here present and or online to participate in this hearing. Any questions on House Bill 1360?
Rebecca, will you be able to provide the commissioners the heads up on when that hearing will occur?
Yes, we will do that. So usually schedules are posted the Thursday before, every Thursday for the coming week. So sometimes it's Friday morning, sometimes there are additions, but I anticipate this one not being next week, but maybe one of the following weeks after that. So yes, we will certainly let the commission know, but it may not be, you won't get weeks notice, it'll be a week.
Okay.
The next one that I want to give the commission an update on is House Bill 1469. This is statements of interest. We call these financial disclosure statements. The nomenclature doesn't really matter. What this bill is the result of the commission and the Secretary of State's collaborative work on needed improvements to the filed statement of interest that are done with the Secretary of State's office. This bill was introduced by Representative Bosch, and it was co-sponsored by Representative LaFour and Senator Hogue. A hearing on this bill also has not been set. We will continue working with the Secretary of State as well as Representative Bosch to make sure that they have information and that we have all of our testimony put together so that everybody knows what the goal and the aim of this piece of legislation is. Any questions on statements of interest? The last update that I wanted to provide the commission on is Senate and House conflict of interest rules. And this is really a long way of saying, everything that I included in the memo is a long way of saying that we are continuing to help the Senate and the House with these rules. We have continuing, ongoing is what I would call them, discussions with Legislative Council in this regard, and we will continue to have those discussions. So this is just letting the commission know that we're still working on those. We have worked on a script that will go over to Legislative Council in the next day or two for their review to allow legislators to disclose a potential conflict of interest and the process, just to kind of help them out. What was that? Yeah, to walk them through that. Logan worked on that, and it's very similar to the script that Dave reads, or, with the same intent, I guess, that Dave reads as we go into executive session. So that way we have all the language, we have everything that's included, so that it allows them to process it quickly. Any comments, questions, or concerns on the last one, which was Senate and House conflict of interest rules?
So basically, that's a helpful effort that we can provide to help the legislators follow the rule with an efficient process.
Yes. So what kind of happens is, because there hasn't been a lot of disclosure on potential conflicts of interest in the past, when it does happen, there does seem to be just some procedural confusion or procedural questions about what happens. And so we want to make sure that we have a process that's good and that they can follow something. This is also something that legislators said, hey, could you guys do this? And we said, yes, we can do that. So that is in response to their questions and an effort to do that. So, but we are working with legislative council on that as well.
And we already had a good discussion with legislative
Yeah,
council
we did.
about it as well, so. More to come on that.
Good. I think it's a good example of us providing collaboration and cooperation to help with the process. Any other questions? Okay, Rebecca.
All right. So Dave, I think we are ready. That concludes my executive director report, what we've been up to for the last month. And it's all legislation for the next few weeks or few months anyway. But I think we are ready to move on to number 5, Dave.
Okay, please do.
Okay. Number 5 on the agenda is conversion of online forms. So we have talked a lot over the last year and a half about the use of online forms. The commission has moved all of its forms online. We do have paper copies available as requested. We've also moved to have filings. In other words, when the forms are completed and they come to us, available online through our website. This is obviously limited to those filings that we receive that are open records. The ones that are confidential, i.e., for example, complaints or things that would later move through the enforcement process, those would not be going up on the website. I want to make that very clear for the public listening. These are just moving the filings that are public records so that they are available on the website. We have started to do that. We have transitioned. We've talked about this, I believe, as Alicia said, at the December meeting. We were specifically talking about that meeting notice form and moving that to be accessible by the public online and having that be searchable and organized. There is an additional requirement that we need to convert those or make them a searchable form. So we talked about doing that with the meeting notice form to make those searchable. The cost of that is approximately $1,300, and we think that's a little high, right? Or is that going to be accurate?
So we haven't received the bill for the first one that we did yet, so I don't have
Okay.
a factual amount, but the first one we did was minimal fields. So I think the meeting notice might be a little bit more, but the other two might be a little bit less.
Okay. So we estimate it to be about $1,300. I'm requesting that the commission authorize staff to also request that NDIT make our other 2 forms that are publicly or that can be publicly available, which is the quasi-judicial appearance of bias form and the conflict of interest form, that we also request NDIT to convert those to searchable forms. The reason that I am requesting authority from the commission is because the cost of this project, including the original form plus the additional 2 forms that we're requesting today, comes to a total of approximately $4,500. And according to the commission's policies and procedure 10 on our fiscal policy, when an expenditure is in this amount, the executive director needs to have authorization from the commission to do that. So with that explanation, I am at this point asking the commission to consider, to discuss, and then to authorize commission staff to expend those funds to create web forms for the meeting notice, conflict of interest, and quasi-judicial forms to turn those into searchable documents that can be available online.
Okay, any questions?
Dave, this is Murray. I have a question. If this motion is approved, would it reduce the end of biennium balance to about $10,000?
It would reduce, so we already had 1,500 planned in that ending balance, so by approximately 3,000. So it would move us from that 15 to around 12,000 for an ending biennium balance.
I move the to authorize Executive Director Benstock to expend funds of approximately $4,500 to create web forms for meeting notice, conflict of interest, and quasi-judicial forms.
I'll second it.
Any further discussion? Okay, we have a motion. Alicia, please call the roll.
Dave Anderson,
Aye.
Ward Kozer,
Aye.
Maurice Sagsby,
Aye.
Cynthia Lindquist,
Aye.
Ron Goodman.
Aye.
Motion carried. Okay, Rebecca?
Dave, are we ready to move to item number 6, discussion of legislative bills that are affecting the Ethics Commission?
Yes, please.
Do you want to move straight to that, or do you want to take a break before we do that? I anticipate this taking quite a bit of time, Dave.
Okay, I like that suggestion. So I have 9:56. Let's take a right 9:56. So let's take a 15-minute break. So we would reconvene at 10 after 10.
Okay.
Okay, we are on break. Looks like we're all back, Rebecca, so I'll call the meeting back to order. And please continue.
So we are on item number 6, as Chair Anderson said. This is discussion of legislative bills affecting the Ethics Commission. So I'm going to give just a little bit of a background about how we came to the list and the things that we are going to discuss today. There have been a lot of bills. I don't have an exact number. Do we have an exact number of how many bills have come in?
It's right around that.
Right around 1,000. Okay. So there are about 1,000 bills that have come in as of the last time we checked, which we do check frequently. The commission is reading the bills as they come in, checking to see if they affect either the duties, the processes, meaning our operations, or the authority of the commission, right? So there's kind of a few different areas that we are tuning in on. Patrick, Logan, and Murray are leading those efforts. We had a meeting last Friday to kind of say, all right, where's everybody? What are we tracking? What have we been following? And so we are watching the bills come in. We have a list that we are working on. It is still a draft of the ones that we are monitoring. So there are some bills that we are monitoring, and then there are some that we are closely monitoring, but there are others that we really do impact or hit on the authority, the duties, or the operations of the commission, that we want to get some direction from the commission on how to proceed with any testimony that we may need to submit on these bills. And so those are the ones that we have for today. I can tell you right now that this is not an exhaustive list of the ones that we want the commission to be talking about. These are the ones that we were able to kind of come up with or discuss, and we're ready to present to the commission. I anticipate that within the next, well, the last bills come out, other than the delayed bills committee, come out on January 27th. So I anticipate sometime after January 27th, asking Chair Anderson to get the commission back together on some new bills that may come in. So I do anticipate having to do this again. This is round 1. Is that a good way to say that? This is the first round of ones that the commission needs to be apprised of specifically. All of these bills we have attached to your memo so that you have the language and that you can look at that as we go through that. Would it be helpful to have Alicia put the language of the bill up as we go through it? I just had that thought. That might be helpful.
Yeah, I
Yeah.
think so.
Yes.
Okay. So we're going to start with House Bill 1257. So this bill relates to organizational session of the Legislative Assembly. The portion, this bill does not say Ethics Commission. It does not directly affect the commission, other than a portion, Alicia, if you will go to page 2, that requires this section that during organizational session, there's a new requirement that a report be presented by each constitutional office during a joint session. The recommendation that I have for the commission and why we are interested in this is because this is something that is frequently done by other states. We do see yearly or biannually reports from most offices. We had the opportunity to do that before the Interim Judiciary Committee in September of this last year to provide a report to them. And we felt that that was a very productive opportunity to give the legislature a review of, hey, how are things going? What are issues that have come up? What are things that we've done? So I am recommending that the commission, while maintaining a neutral position on the bill itself, because there are other components of it, that we just demonstrate or we communicate to the legislature the willingness of the commission to present a report to the joint session as it increases transparency of the commission's operations as well as overall government operations. So we don't plan on verbally testifying on this bill because it is a short a bill. There's a lot of there's a lot of things that are outside the purview of the commission, but really we want to inform the legislature that we are willing to present a report and that we are definitely willing to increase transparency on the commission's operations. So with that, that is what I have on this particular bill. Just that we want to present, not present, but just submit written testimony on this one. Any comments, questions, discussion on this?
I would make a motion to authorize commission staff to provide neutral testimony on this bill in accordance with the commission's discussion.
I'll second.
Okay, we have a motion and a second. Any further discussion? Okay, let's take the roll call vote, please, Alicia.
Dave Anderson,
Aye.
Ron Goodman,
Aye.
Ward Kozer,
Aye.
Cynthia Lindquist,
Aye.
Murray Sigsbee.
Aye.
Motion carried. Next one, Rebecca.
Yeah, let's move on to House Bill 1141. This is going to be attachment 14. Alicia already has it up. I was giving you a moment, sorry. House Bill 1141 is introduced, sets limits on state or local governments from contributing to a private organization that has endorsed a candidate of publicly supported, a candidate or has publicly supported or opposed a ballot measure. The enforcement mechanism and why this one is definitely on our radar is if you go to the enforcement mechanism. So Felicia, if you can scroll down to the bottom of page 1, the enforcement mechanism that is created by this bill allows an individual alleging a violation under this section to file a complaint with the Ethics Commission as authorized in Chapter 54, which is the Ethics Commission's complaint process. But if you go to the subsequent portions of this bill, it then has a section 5 and 6 on page 2 that gives some pretty specific direction about allegations of criminal conduct, that the commission shall refer to a state's attorney of the county in which the alleged criminal conduct has occurred. Also in section 6, there is reference to the fact that the state's attorney shall, very mandatory language, shall prosecute that violation. But if they refuse to, then the commission refers the matter to the attorney general. And it's by a majority of commissioners. If the commission authorizes the attorney general to prosecute the action, the attorney general then shall file the action in the Supreme Court. We briefly talked about this bill at the special meeting on the 13th, I believe it was. The reason was that we were looking for direction on this one because this testimony, the hearing on this was previously set for last week. It has now moved. At this time, I am recommending, I shouldn't say even recommending, just wanted to discuss a little bit about this bill. And we have already prepared the testimony on this one. You will find that in attachment 15. This is a draft. I will tell you this testimony is draft, but I suggest that the commission maintain a neutral position on the bill, but really submit testimony highlighting that there are certain procedural hurdles that are raised in this bill, including the fact that in number 5, this requires the commission to require the commission to refer the matter to a state's attorney. The commission has been moving in its new enforcement process away from that mandatory criminal referral and instead to a discretionary referral. The language of this bill is also inconsistent with House Bill 1360. It's still using the complaint process. It uses language that is inconsistent and probably inconsistent just with the process in general. And then last, if asked, the commission can address this issue instead of having this direction to the Attorney General. The Attorney General, I just want to point out, and this is really coming back to what we've previously discussed and is included in the testimony, that the Attorney General and state's attorneys, they are the ones that have the criminal prosecutorial discretion regarding criminal conduct. The commission does not. So the section in number 6 is interesting. I think I use the word unique language. And just that if there is a concern or that the legislature wants this to be addressed, that the better way to do that is to address that through the commission's new enforcement process. And you will see that outlined in the testimony. I know I have a motion, a requested action by the commission to authorize staff to provide neutral testimony. I actually think we already did that, didn't we, at the last meeting? What was that? Yeah. So I think we already did that, so I don't believe we need a motion on this. But any comments, questions, thoughts from the commission on this one? I know we've already had a discussion about it at the previous meeting.
Rebecca, I like the testimony you put together because sometimes it's a little tough to understand the bill, but your testimony reflects kind of exactly the concerns, and I thought that summed it up very well. So I appreciated that.
So that is Logan put that together. And I also thought that it was good. That's why we wanted to provide it to the commission.
Yeah, it succinctly described the problems, concerns we have, and put it in a form that was easy to understand. So I appreciate that, Logan. Any other discussion from the commissioners? Okay, I would entertain a motion to authorize commission staff to provide neutral testimony on this bill in accordance to our recent discussion here.
So moved.
Second.
Any further discussion on this? Okay, Alicia, let's please call the roll vote.
Dave Anderson,
Aye.
Ron Goodman,
Aye.
Ward Kozer,
Aye.
Susie Lindquist,
Aye.
Murray Stegsby.
Aye.
Motion carried. Thank you for that. Let's continue.
Moving on to House Bill 1286. This is the ultimate and true source of funds bill. That's what we call it. Some people refer to it as dark money. This bill, a similar bill, has been introduced in previous legislative sessions. As introduced, it creates a reporting mechanism and an enforcement mechanism to identify the ultimate and true source of funds for campaigns. So if we look at, I think this is an 11-page bill. If you go to page 3, Alicia, if you go to page 3, maybe 4. Yep, top of page 4. So the reason that we flagged this bill, there are other reasons we flagged this bill, but the Ethics Commission is included in a definition within this section. And this bill, as it is outlined, there really is this who needs to report certain funds and certain expenditures. And then the second portion of it, Alicia, if you can go down, I think it's on page 9. Bottom of page 8. So on the bottom of page 8, this is where what ends up, this is the enforcement. So the mechanism to enforce the disclosure of these funds. And so you will see that this particular section of section 4 of the bill adds that the Secretary of State becomes an investigator in these instances. And he may do so, or the office may do so with or without a complaint. It outlines a procedure for filing a complaint with the Secretary of State's office. And then in number 4, there is a provision that if the Secretary of State dismisses a complaint or fails to act on a complaint, that a complainant may then file an action against the Secretary of State. So when we talk about, I apologize, I jumped ahead. The other portion is in section 5. There is this resident taxpayer right civil action. This is language that comes from Article 14 of the Constitution, that if the chapter on the ultimate and true source of funds does not fully vindicate or provide for the enforcement as outlined in the Constitution, then a civil action may be brought by a resident taxpayer. So what is interesting about this bill, and I want to focus a little bit on just the enforcement side, is that this has the investigation going to the Secretary of State. I believe the Secretary of State has testified multiple times that they are not an investigative agency. The other portion is that it opens the Secretary of State up to have a number or lawsuits brought against that office for not investigating or taking action on complaints. That it's not reasonable. So this is, yeah, we have some concerns about that particular language being included with this type of bill, that it really does open up quite a bit of exposure for the Secretary of State's office and potentially the Ethics Commission as also an individual or an entity that is involved in this area. So I want to caution the Commission about those particular processes. As we talk about the substance of this bill, there are some concerning things about it as well. I did have a discussion with Commissioner Sagstein on this yesterday, and I'm going to ask that he talk a little bit about that.
I just want to advise the commissioners that I try to review every single bill that's introduced, not only because I'm a member of the Ethics Commission, but I'm also the Synod attorney for the Western North Dakota Synod of the Evangelical Lutheran Church in America. And so I advise the two bishops, East and West, about legislation that may be church related. So I try to review all of these bills. When I came to 1286, I became concerned about it, not only for the reasons that Rebecca mentioned, but for a couple of other reasons. Alicia, if you'll go to page 8, to the top of section 3, This is really the crux of this bill, that at line 4, within 10 days of first dispersing an amount of more than $200 in traceable funds for expenditures during an election cycle, a covered person shall file a statement with the Secretary of State disclosing where that money came from and where it's going. And so that's the good part of this bill. So the bill is trying to get at the true source of funds. So and then lower in section 2 you can see the Secretary of State shall make the information filed accessible to the public on a website in a searchable, machine readable format. So the purpose is to file information about expenditures, and now I'm talking about particularly for a ballot measure, that people giving money to influence a ballot measure must report to the Secretary of State, and the Secretary of State makes that information available to the public. So now, if you go back to, so that covered people are to make those reports. So now, Alicia, if you'll go back to page 3, the bottom of page 3, it says defines covered person, and these are the people to make the reports. So a covered person means any person that spends more than $200 in an election cycle on expenditures to influence ballot measures. Then it continues, this term does not include, in D, a nonprofit organization exempt from federal taxation under 501c3 of the Internal Revenue Code. So I work with the 501c3 of the Internal Revenue Code virtually every day on church-related and nonprofit issues. So what this section means, that everybody who spends money to influence the ballot measure must report to the Secretary of State, except 501c3 nonprofit organization, which includes thousands of organizations in North Dakota. That includes educational institutions, churches, charities, and so any of those people are exempt and wouldn't have to comply with this law. That is of concern to me, and I think it creates a huge gap in this bill. And Rebecca has addressed the enforcement issues, and I agree with her on that issue. That's what I have to say about that.
Thank you,
Thank you,
Murray.
Murray.
Any other discussion?
By the way, 501c3 issues are really complicated issues, and I hope I didn't make your eyes glaze over when I talked about those.
So I think, Murray, if it's okay, I can take it from here as to, this bill as introduced has issues that need to be addressed in a very thoughtful and meaningful way. And one of the discussion points is how do we do that? We are under the hearing on this bill is on Thursday, and there are certain problems that are presented or issues that are presented from a substantive side as well as an enforcement side on this particular bill. And this really does require, as Murray said, some very thorough thought and consideration and legal research that we don't have the ability in the next 2 days to get done, unfortunately.
Dave, I have a comment here.
Okay.
After reading these bills and seeing how many bills interface with each other on disclosure, transparency, confidentiality, putting information public, who does the enforcement, it suggests to me that that instead of trying to compress all of these issues into the next several days during this session, that it may be wise to explore with the legislative leadership whether the legislature should transfer or postpone or table some of these issues to a legislative study so that these issues can be methodically discussed over the entire period between the end of this session and the beginning of the next session during an interim study. And there are two ways to do that. Either the legislature could do this in the normal course of an interim study, or the ethics committee could host a study. But I think some of these issues are so complicated and so interrelated that and so many bills are introduced by so many different legislators who don't have the time to talk about how they're connected and interrelated. I really think that a more concerted, lengthy, focused effort should be given to the entire program, that between the Ethics Commission and the Secretary of State and other organizations that are interrelated, so that at the end of a interim session, there could be one or more bills that are well thought out and integrated. Here ends my comment.
Any other discussion or questions? Okay, I would entertain a motion to authorize commission staff to provide neutral testimony on this bill in accordance with our recent discussion.
So move.
Second.
Any further
Thank-
discussion on? Yes, go ahead, Rebecca.
I would like specifically direction from the commission. I think what we will do is point out, I think that the maintaining a neutral status is acceptable, and then pointing out some of the issues or the concerns that the commission has. I would specifically like direction about proposing, whether it be legislative or within the context of commission, the ethics commission's already given direction to our council, which was discussed, I believe it was at I'm going to get the date wrong. It was either, I think it was the August meeting or the July meeting, regarding a review of campaign finance and disclosure laws in general, that we can work with the stakeholders, as Marie mentioned. I guess I would like to get direction from the commission to specifically do that, or at least have, based on the discussion, I think that's what I would do, but I'd really like to get feedback on the commission to make sure that we are understanding what the commission is asking of us. Yeah, and that those efforts, or that the legislature, etc.
Okay. I have a question.
Mhm.
Given what I've heard, why isn't our motion in opposition? I mean, I guess I get it, but and then I'm not sure of the process either. So if we would say we're opposing this, and couldn't we say, here's why? I mean, we can point out all these points that we've just discussed.
I thought it was
Or
neutral testimony.
yeah. Well,
So
that's the motion that we're discussing. We said we're gonna be neutral on this, but would we be better situated by saying we oppose this particular bill the way it's couched right now, the way it's drafted now?
But Rebecca, you're asking for the ability to point out problems. We'd still be neutral, but you'd like to point out a couple of significant issues with the bill.
So in the memo to the commission, I included that we maintain a neutral, I mean, that was the recommendation. The reason that I did that is because, and I will tell you my reason, but I also want to be very clear that I will take direction from the commission. I maintained that neutrality in the request because the underlying purpose of this is to include more disclosure when it comes to the ultimate and true source of funds. The problem that we run into is that the mechanism and the substance of this does have significant issues. So I understand Cindy's concern that perhaps this is really opposition testimony and it's really not neutral. So I presented it as a neutral testimony. That is the motion before the commission. But if the commission would like to take the approach of opposition with sufficient explanation, you know, I'm gonna do what I think that's left to the commission to decide, not to me as executive director.
Dave, this is Murray. I just want to comment that I think the concept of the bill is very positive. That to try to display or make available to the public the true source of funds. The manner in which there are at least two problems with that, in that one is that if the provision about 501c3 exception is left in the bill, it leaves a huge gap in the purpose of the bill. And second of all, that the enforcement should be fixed. So I think that the overall provision is that the commission supports the bill, but has an opposition to other parts of the bill. So really has to be neutral to explain both sides. Does that make any sense?
Okay. Yeah, that helps, Murray. That helps. And I understand and appreciate, Rebecca, your position as our exec director to bring this forward this way. And I guess I'm just raising it because I'm just trying to, I agree. I think this is something important. I think it's relevant in what people have talked about. So it's a needed bill or piece of legislation. I have trouble with those points already been mentioned by everybody else. So yeah. So I guess I'll pull back my question. I'm okay with the neutral stance.
Cindy, I think your question was valid and a good question to trigger discussion. So thank you for it.
So with the
Mr. Chair, I'm getting a notice that my battery's dying. Can you just, after this vote, can you just sit tight for a couple of minutes so that I can find an outlet that actually works in my brother's home?
Okay.
Okay.
Any more discussion? So really, we're still maintaining that we want to maintain a neutral view of this, but it's okay for our staff to point out the concerns we have within the bill.
Yes.
So do we have to change the motion then, Logan? So if I entertain a motion to authorize commission staff to provide neutral testimony with concerns on the bill in accordance with our recent discussion.
We don't need to change the motion because it took into effect the commission's discussion as we have it. So we're good there. I
Okay,
guess just as a point of clarification for us as we begin drafting that testimony, I just want to clarify that the commission is okay with us relaying to the legislature that the commission is willing to lead those efforts to research these issues and report back to them if they're good with that.
yes.
That helps.
Okay, I will entertain a motion to authorize commission staff to provide neutral testimony on this bill in accordance with the discussion we just had.
Dave, we have a motion on the
There's-
table.
yeah.
We just vote on it.
Answer, yeah.
Oh, did I?
Motion and seconded.
We're just doing the discussion.
Yeah, yeah.
I got a little confused. Did I get all mixed up by the further discussion?
Yeah.
Okay.
That was it.
That was the further discussion, Dave. Yep.
Oh, okay. I guess I didn't realize it was in the further discussion part. Okay, Alicia, let's take the vote, please.
Dave Anderson,
Aye.
Ron Goodman,
Aye.
Cynthia Lindquist,
Aye.
Murray Sagsby,
Aye.
Mark Moser.
Aye.
Motion carried. Hey, Rebecca, next one, please.
Are we going to pause for Murray's power supply?
Oh, yes.
concern?
Yeah, let's take a, Mary, find a better outlet.
I got plugged in. Thank you.
Oh, okay. Way to multitask there.
So are we good to continue?
Yes, please.
All right. Next up on our list is House Bill 1434. This one was flagged by our staff based upon the implications for administrative rules. So House Bill 1434 is introduced, sets an expiration date for administrative rules as well as commission rules. So the reason that we're talking about administrative rules and commission rules is, if you'll remember, way back in 2019, which is not that long ago, but seems like that a long ago sometimes, commission rules are adopted pursuant to certain aspects or certain sections of the Administrative, I'm blanking on the name now, Practices Act. Is that the right one?
Administrative
Okay.
Agencies Act.
Yes, Administrative Agencies Practice Act, that we follow some of the portions of that particular set of Century Code in order to adopt commission rules. So sometimes administrative rules and commission rules get all lumped together. There is a distinction. So administrative rules are created from the legislature granting somebody authority to create rules in that area, where the commission rules are not done pursuant to or based upon any legislative authority that goes to the commission, but from its constitutional directives itself. So just a point of clarification that they are distinct. However, in 1434, this sets an expiration date for both types of rules. I believe that this was included just because there is sections of 2832 that apply to both the commission and to administrative agencies. At the time of this expiration, the governor reviews the rules and can either extend the expiration date or require an agency or the commission to amend or repeal the rule. So As this bill is introduced, if we base just upon the language that is introduced in this bill, I need to recommend that the commission testify in opposition to this bill, as it gives the governor discretion to amend or to repeal commission adopted rules. As I already articulated, commission rules are adopted pursuant to that constitutional directive, not authority given to it by the legislature or by the governor. So the application of this process, as articulated in 1434, it does create a separation of powers concern. When we saw this bill come in, as there is a lot of confusion, not a lot, there is some confusion with ethics commission rules being administrative rules or commission rules. I reached out to the primary bill sponsor, who is Representative O'Brien. We had a good conversation. She well understood and was amenable to an amendment removing the commission's rules from this process. She asked us specifically for what would be the easiest way to amend it to remove the commission's rules. It was not her intent to create this separation of power concern, but did just consequently lump those in together. So with consideration of the amendment, I recommend that the commission monitor this bill, and if an amendment removing commission rules is adopted, if it is adopted, then we don't need to submit testimony, but we will simply monitor. If there is not an amendment introduced, then I need to recommend that the commission submit testimony in opposition to the bill. So this motion is really kind of premised on the fact that if there is an amendment that does not remove the commission rules from this expiration, then I'm asking permission from the commission or authorization to provide opposition testimony. I feel like I went a little back and forth there.
And when it do neutral testimony to support the amendment.
Yes, and we may need to do neutral testimony to support the amendment. So I think if we did a motion to authorize commission staff to testify in accordance with the discussion, I think that would be sufficient. So that is what I, yep, sorry.
Do I have a motion to that effect?
So moved.
Support.
Any additional discussion? Okay, Alicia, please call the roll vote.
Dave Anderson,
Aye.
Marie Sigsby,
Aye.
Ron Goodman,
Aye.
Casey Lindquist,
Aye.
Bert Hoser.
Aye.
Motion carried. Next one, Rebecca.
Yep, last piece of legislation for today that this is more of a 1505. This one is presenting, we're not asking for direction at this time from the commission as to testifying in support, neutral, or in opposition, but this is really just providing the notice to the commission about the introduction of this piece of legislation. This does directly affect the operations procedures of the Ethics Commission. So there's two essential portions of this. Section 1, as it is introduced, this is amending 12.1.1302. This is speculating or wagering on official action or information. This ends up, if you move on to page 2, Alicia, this provides immunity and then potential affirmative defenses for individuals who are found or who may be prosecuted for this particular subsection. The first subsection 3, you will see that immunity clause that is for the prosecution of individuals under that section. You will see the 3 requirements of that. I don't want to focus a whole lot on that, but want to make the commission aware of section 2. Alicia, if you can go down. This particular section, we would like to, and we are going to have ongoing discussions with the sponsors of the bill, who is Representative LaFour and Senator Hogue, as well as other legislators. So this is creating an affirmative defense in one instance, and then also creating an immunity provision. So we are particularly focused on subsection 2 of section 2, which says informal advice from a staff member of the Ethics Commission, and that when you rely on that advice, it is an affirmative defense in a prosecution of an individual voting on a measure in a legislative committee or the Senate or the House of Representatives. The concern that we have with this section is the use of informal advice from staff member of the Ethics Commission. That's not well defined. Is that a quick conversation in the hallway? Is it we need to do a much deeper dive into what the intent of this section is and how this can be communicated, and just understanding this particular section. This certainly creates evidentiary issues with having I got informal advice, and if it was not in writing, if it was a comment, what was the scope of that conversation? There are a lot of different things that come into play on this. So we are going to be working on this particular section. I anticipate that we will have good discussions on that. So I wanted to make the commission aware of that. The other thing, substantial thing that this does in section 4, section 5, is it makes significant changes to confidential information and how, what the scope and applicability of confidentiality is to the commission's complaint process. So you will see right away in subsection 1 of section 5, you will see it on line 12 in front of you. It says that the following, meaning all of the things that are listed subsequently, are confidential records under the open records law when in possession of the commission. So it limits the confidentiality to only when it is in possession of the commission. So for instance, if we have information that then we need to request from another state agency, or a local, it could be a local agency for that matter, that information that we need to share in order to conduct an investigation loses the confidentiality at that point. That is, so currently the confidential status applies regardless of what agency has or receives that information from the commission. So there are some things in this particular section dealing with confidentiality that we do need to address. And so we will have good discussions on those particular things. Those are the ones that I wanted to alert the commission to. We're going to continue. I just recommend that the commission staff continue to assess its position on this bill as it moves through the legislative process, and that we'll continue to have discussions with the legislature regarding this language. So at this time, I'm going to recommend that the commission not take a position on the bill, but just know that we are working with the legislature on this language. Any concerns, questions, comments on 1505?
Any other discussion? Okay. So does that conclude the discussion of the bills affecting the commission?
For today, Dave, yes, there are. We will get through the remainder of the bills. I think there are a few other ones that we will be asking for direction on in the coming weeks, but these are the ones that were either already on our mind because hearings were set and then canceled, that we've already started to have discussions on, or that we needed to submit testimony in short time on.
Okay, thank you for that. I think for the benefit of the commission, it's not just the bills that we've talked about that we've asked for help to sponsor and our own bills, but if you look at this past discussion, all these extra bills that affect what the commission does, our staff has done a really good job of summarizing that and keeping ahead of that. So I just want to point out how much extra efforts involved on that. So Patrick, Logan, Rebecca, Alicia, thanks for all that. That's a lot of extra effort.
And don't forget about Murray. Murray is also helping
yeah.
on that front.
I forgot. Thanks, Murray, for your help on the side there. I know you can be extra productive because it's not very cold where you're at. But we do appreciate your experience and your help on this. So thank you for that. But there is, it's just to me, when I looked through all that, looked at the memorandum, that is a lot of extra work. That's the wrong term, but there's a lot of extra pieces to keep track of. And they're doing a good job, but it's really brings home to me with all the extra things. It's the half dozen things we had in mind that we were proposing and tracking. And then there are these, and there's going to be more to come.
Yeah.
So I guess I'm pointing out the challenge that comes with, that comes for our folks. Any other discussions on that?
No, I just want to add one comment, Dave, that there are going to be more bills coming that we want to ask on, and we'll be getting back to the commission on those. I think I've already said.
More to come. Any other comment? Go ahead.
Oh, nope, sorry.
So that wraps up that discussion. Anything further in that area before we move on?
Nothing from Bismarck.
Okay, then I guess we will look at the discussion of the complaint. Is that where we're at?
Yep.
Okay. The next item on the agenda is complaint number 24-041. This item must be discussed in an executive session. The legal authority for closing this portion of the meeting is North Dakota Century Code, Chapter 54-66-12, Section 1, North Dakota Century Code, Chapter 54-66-12, Section 3, and North Dakota Century Code, Chapter 44-04-19.2, Section 1. The topic or purpose of this executive session is discussion on complaint number 24-041. Information regarding the content and parties to the complaint to the Commission is confidential. As the complaint must be discussed in executive session, no motion is needed to enter executive session. The executive session will be recorded, and all members of the governing body are reminded to limit their discussion during the executive session to the announced topic. Any collective decision, collective commitment, or other final action by the governing body must occur after reconvenes an open meeting. The prohibition on taking final action during the executive session does not apply to providing guidance or instructions to our attorney. We will now ask the members of the public who are attending the meeting to leave the meeting. We anticipate adjourning the executive session and reconvening the open portion of the meeting at approximately, any thoughts?
11:20 per Logan, according to Logan. 11:15.
10 minutes.
11:15, Logan says.
Okay. Reconvening at 11:15. The minutes will show that the executive session began at 11:05. Read that right? And was attended by Commissioners Ron Goodman, Ward Kozer, Cynthia Lindquist, Murray Sagsveen, and Dave Anderson, along with Executive Director Rebecca Benstock, General Counsel Logan Carpenter, Operations Administrator Alicia Mayer, and Legislative Intern Patrick Fries. Okay, I think that takes care of that. We can now exit and reconvene in executive session.